Hello, and welcome to this session, Medical Marijuana and Industrial Hemp. I would like to introduce Erik Giles. Erik is a citizen of the Muskogee Nation of Oklahoma, from the Broken Arrow tribal town and the Big Cat clan. He is certified in crime prevention through environmental design standards and is a leadership in energy and environmental design accredited professional. He is a former member of the American Institute of Certified Planners and Iroquois Nationals lacrosse team player. Since we are recording this, I have a microphone here. So if you have any questions or comments, just raise your hand and I will bring the microphone to you. Thank you. One last thing, since this is a CLE meeting in Minnesota, there's a sign-in sheet that you can sign at the end.
Thank you, Ryan. Good morning, everyone. It's a pleasure to be here with you all. My name is Erik Giles. I serve as an associate attorney at the law firm Drummond and Woodsum, in the heart of Indian country, located in Portland, Maine. So when I come out to here and to be back home for me, it's I really am grateful to have this opportunity. So thank you all. Drummond Woodsum, the law firm, we've been working with about 5 different tribal clients in our regulated substances practice group, and those in states of New York, Michigan, California, and Washington. So as we talk about this and the alternative for tribes to get into the cannabis and hemp market, it's important to know the distinction between hemp and marijuana. Basically, hemp and marijuana are the names for products produced from the same plant, cannabis sativa. Under the U.S. Controlled Substances Act, the cannabis plant itself is illegal, in addition to products produced from the plant. Hemp generally refers to varieties of the plant that are low in THC, while marijuana refers to varieties that are high in THC. The high levels of THC content is what is that psychoactive component for people when they consume marijuana. The line between hemp and marijuana is based on a 0.3% THC content by dry weight. Below that level, it's hemp, and above it, it's marijuana. Marijuana is classified as a Schedule I drug. Therefore, anyone who's producing, selling, or consuming weed products is committing a felony. And it doesn't matter what state law has authorized or even tribal law. Until the federal law has been amended to take marijuana itself off the Controlled Substances Act, everyone who's engaging in any kind of commerce or as an end user is committing a federal felony. Okay, but that's the current state right now. And as everyone knows, that is changing. And it's been changing pretty quickly over the last 4 to 5 years. Currently, the national trend.
Hi, this is Ryan. I'm in the Awantana room 1 and 2, and the
Is
oh, it is.
that just reminded me of the Naked Gun when he goes out and he leaves a microphone on and he goes to the bathroom. Okay, but so currently, the trend is toward legalization, and so far there's about 30 states, including Washington, D.C., have legalized medical marijuana, and so far 10 states have legalized full adult use recreational legalization. That's Alaska, California, Colorado, Maine, Massachusetts, Michigan, Nevada, Oregon, Vermont, and Washington. So it's pretty clear where the trend is going. The business opportunities are there. A lot of the market research that we've worked with in consulting and developing feasibility analyses show that this is going to be a billion-dollar industry, and those dispensary retail sales are going to be the prime driver of the market. In hemp, what you saw in the last 3 to 4 years was a high increase in production, and what the expecting is that sales are going to catch up with what's been produced so far due to the 2018 Farm Bill. And hemp products, if you look at it, they generally refer to again the cannabis sativa plant that is not psychoactive and has that low amount of THC. And what it has is basically it's been shown to have a broad range of uses, potential to create new agriculture jobs, and creation of food products like hemp seed, as well as CBD oils, which is very popular now, and also textiles. Market entry into the hemp industry. There's significant competition internationally, a lot of international suppliers, and established farmers that are already operating these hemp production facilities. Most operations in the U.S., they import and manufacture into byproducts, into food and cosmetics, and then also create food processing and manufacturing operations as well. In 2016, the average gross profit per acre on hemp was about $468. So this is just a showing of what the sales by product categories. What you can see there is the CBD oils is really the driver of the market products, but you also have hemp seeds, hemp juice, hemp protein. So a lot of different uses for that. Also biofuels, that's something else that's being looked at as well. Retail sales for CBD products, again, that's another multi-billion-dollar projection that is a market opportunity as well. Hemp farming and processing. So now that the 2018 Farm Bill has been passed, we think that there's going to be opportunity for tribes as well as allottees to be able to sell hemp products under some sort of tribal brand. But what has to be really taken into account are the upfront cultivation costs and capital improvements that are going to be required to create a facility. It's large-scale production, field equipment, machinery, field security, fencing, video surveillance, labor requirements. It's easy to transition into farming for hemp, but you have to have the people that know how to do it. And so there's a pool out there where it's becoming more common, but you're still transitioning into a new field. So you have to understand soil capacity, nutrients, topsoil minerals, fertilizer requirements, maintaining irrigation, and there's a hook now on the 2018 Farm Bill, which it removed hemp from the Controlled Substances Act, and it allows states and tribes to engage in hemp production and to sell hemp products across state lines. That was a huge problem prior to the Farm Bill. There were pilot projects out there, but they couldn't sell their products outside of the state from where they were making them. So that's all been taken care of now. And so what will happen is a tribe and a state will submit their hemp production plans. But the hook is they are going to be subject to USDA regulations. And so the USDA has now come out and said that we're not approving any plans, and we're going to have draft regulations that we're going to start this year, and then hopefully they'll have final regulations next year. So what that means is if you're going to start to engage in hemp production now, you would be having to do that under the 2014 Farm Bill. And under the 2014 Farm Bill, that's where I was talking about. It was very limited. Your partner, you had to have a research partner, like an academic institution. So it was very restrictive in that sense. But basically, overall startup costs for either a cannabis or hemp operation, we've estimated to be about $3 to $5 million, with about 30,000 square feet for growing and manufacturing facilities. And then, obviously, if you don't have those, you'll have like that'll increase about to 5 to 8 million. As I mentioned, that it's a growing industry. You can see from where in different states there's more hemp farming that's taking place. In 2017, Colorado was the top hemp producing state. But that in 2018, Montana has now expanded production to about 22,000 acres. So we had to talk about how we're going to be doing this legally. And under the Obama administration, the Department of Justice had issued multiple policy memos instructing U.S. attorneys not to interfere with state legalization efforts unless certain enforcement priorities were implicated. That was known as the Cole memo. The subsequent memo extended the same policy to tribal marijuana experiments. That was known as the Wilkinson memo. These memos have since been rescinded under the Trump administration. They're basically, there's no policy statement that there's going to be no enforcement action against states or tribes. So that means the risk for tribes or states to get into cannabis, whether it's medical or recreational cannabis experiments, the risk is going to go higher because there's nothing that's coming from the U.S. Attorney's Office that's saying we're not going to enforce if you're going to meet these certain standards. Even if you meet the certain standards now, you're still at risk of running afoul with the Attorney's Office. There is a safe harbor for medical marijuana operators. It's called the Robarker-Farr Amendment to the U.S. Department of Justice Appropriations Bills, and it was first put in 2014, where the Department of Justice and DEA, they're prohibited from using federal funds to prosecute people acting in compliance with state medical marijuana laws. Courts have read this memo to mean that, or this amendment to mean that the DEA and Department of Justice cannot prosecute people as long as the defendant can show they are operating in strict compliance with state law. And this amendment has been renewed every year in the appropriations bill. So as we talk about the Farm Bill, again, the highlights of that was removing the cannabis sativa plant from the Controlled Substances Act if it's 0.3% THC on a dry weight basis. Again, that's hemp. And the USDA has to come up with national hemp regulations as expeditiously as practical. So a year and a half time frame, maybe. It doesn't seem that expedited, but in government terms, that's probably like as fast as you're going to go. So, as I mentioned, that the 2014 Farm Bill allowed agricultural pilot programs to govern hemp cultivation. Now, the 2018 Farm Bill allows states and tribes to have a primary responsibility for regulating production by submitting regulatory plans to USDA. If a state or a tribe doesn't submit a plan and an individual wants to get into hemp production, they would have to get their own individual license from USDA. As I mentioned, that USDA says they are not going to really implement the law until after 2019. as mentioned, the plans that are being produced, they, in the Farm Bill had specific categories and criteria that every state and tribe would have to show that they're going to meet. I guess what the USDA regulations are going to do is going to maybe just spell that out in more specific terms. What the 2018 Farm Bill, it bans, if you have a drug felony background within the last 10 years, you can't engage in hemp cultivation. And as I mentioned, this interstate commerce, where you're producing hemp products, now they can be moved from state to state, across state lines. This is just the same as any other crop that's produced on agricultural lands. What the Farm Bill doesn't do, again, it doesn't give any clear guidelines, agency guidelines for manufacturing or processing. The biggest issue right now is the Food and Drug Administration has come down now on hemp products, and so they've sent out another policy statement that FDA has authority to ban CBD from foods, drugs, and cosmetics. And they've actually in Maine, where we've been working on this, they've issued orders to certain retailers to remove all their CBD products from their shelves from retail. So you're not only going to be subject to USDA regulations, administrative regulations for production and cultivation, but now they're saying that your end products is going to have to meet FDA, Food and Drug Administration regulations. One way I thought about this was, I don't know if you're familiar with the food sovereignty movements, in states where they have food sovereignty laws, like for instance, a dairy cow farmer. On his farm, he's producing milk. An individual can go onto his farm and purchase that milk directly from that farmer producer. And that milk that he's purchasing doesn't meet FDA guidelines. And that's under this concept of a food sovereignty law. I think that same approach could apply here, where if you're producing hemp products directly on your tribal land or your allotment, and the customer is coming directly onto the property and purchasing those products, and the tribe has in place a food sovereignty law, I think you enable that kind of transaction to happen. But otherwise, you're going to be having to get your stuff inspected by FDA regulators and meet their minimum requirements. So there's this uncertainty about CBD products is going to continue, but the FDA is going to be they're supposed to be having hearings on this stuff in April. So there'll be time to submit comments. They'll have a rulemaking period where, if you have the coalition, like I know recently there was the Tribal Farm Bill coalition that submitted comments in getting language into the Farm Bill. It will be the same process. There will be an agency rulemaking period where you'll be able to submit comments. Possible federal laws that have been proposed. There's the States Act, which proposes to exempt states who legalize cannabis from compliance with the Controlled Substances Act, and they will also exempt tribes who regulate marijuana in that state to the same level as state laws. That is in every legislation that's been proposed, where they're granting states the ability to implement their own recreational laws. They always have this kind of rider about tribes in that state, and that tribes are always going to have to meet the state law requirements. So tribal control, when I look at this, I come up with basically three different scenarios. You have scenario one where both the state and the tribe have legalized either both medical and adult use marijuana. Tribes then, they'll enter into negotiated compacts, or they'll go under a preemption analysis with its own tribal law. Scenario two, both the state and the tribe have taken no action on legalization, and so essentially that would be a de facto moratorium. And then scenario three, the state has legalized medical or adult use, but there is no tribal law. Or a tribal law has been passed, but there's no state law. And so that's the current context in Oklahoma. In Maine, we have that as well. But I think the bottom line is that tribes are going to need to assert jurisdiction. Just because once the states begin to decriminalize marijuana by regulating medical or adult use, it transforms into a civil regulatory legal framework instead of a criminal jurisdiction. And so when that transition happens, tribes are in the position to regulate and preempt state law. Probably, I mean, if the tribe decided they wanted to engage in this, I would say that the most important aspect of it is that you're generating value on the reservation. Everything is a vertically integrated operation, from your growing, your processing, your retailing. It's all occurring in one area. The courts have shown that once there's the activity is shown to be value generated on the reservation, instead of in the case of the earlier Supreme Court about Colville, when they were retailing cigarettes. The court said that Colville didn't preempt state law and they were subject to state taxation because they were importing cigarettes onto the reservation and selling them out of their smoke shops. And there was a specific discussion in there that it was not deemed to be value generated on the reservation. So here in this scenario, I would argue that when the tribe has a vertically integrated operation and it's all occurring on trust land, that preempts state law and everything is being regulated under tribal law. So this is, certainly when tribes are going to look at this, they can be a market participant, they could just be a regulator, or they can, have a dry reservation. They're not going to. They've made that policy decision that they don't want to engage in this, and they don't want to enable, this kind of substance to be, sold on the reservation. There's a lot of tools to go about that: zoning, land use planning, all those fundamentals of regulating land use activities on the reservation would come into play. So these are my two alternatives I've looked at under tribal control. The first one is the administrator approach. You create a tiered system of licenses. Customers and patients, they would be purchasing from tribal members who have a license issued from the tribe. So a tribal member could get a retail license, open up their own retail distribution site. Another tribal member could become an operator or a cultivator. So there would be all these different tiered licenses that would create an enterprise on the reservation amongst tribal members. The other is the operator approach, which I mentioned was like the tribe is the market participant. Everything is done under tribal control. The tribe would have some sort of authority that regulates the tribal operation, and everything is staffed by tribal members. But under that scenario, that's where the tribe is the market participant. This is what some of these facilities look like. So this is an example of a nursery cultivation facility. where the licensee is allowed to cultivate immature plants, clones, and seeds for sale and distribution, and then they take that and they sell that to other licensees who may or may not be selling flower. But plants ready for harvest, another cultivation facility license to grow marijuana for wholesale and distribution. You have your drying rooms, your trim rooms, testing facilities. This is something that some of the tribes who said that they weren't interested in retailing or growing, but they would like to set up a testing facility that would be licensed under the tribe, but it would also be able to test marijuana produced, outside people who are operating under state licenses. So there are certain areas in the supply chain that tribes could just focus on, and just set up a business in that section, but not really engage in the end retail sales. The packaging and the manufacturing, where you come at the facility, they package and convert the flower into edibles, topicals, concentrates. Something about this is marijuana extraction. That method it's inherently a hazardous substance, and it requires a lot of oversight, environmental compliance. You want to make sure that the waste product that is coming out is all destroyed in an environmentally safe manner. This is one of the hydrocarbon extractors. It creates the what they call it, shatter. What people use to vapor with their vaporizers. Retail store, the final point of sale, display products. There's some laws that they've banned products that resemble like Reese's Pieces candy bars, or they don't want to allow for products that appeal to minors. This flower display. That's the concentrate display. Let's talk about where they're using the hydrocarbon extractor. So there's a way to get into this, and if it's a new entry into this market, you might want to be considering a request for proposals to have some sort of maybe consulting group come in. They could do a market study, figure out how much of the capture of the share that a facility would create, the revenue generated, all your infrastructure requirements. You can do an assessment for where the lands are that are available for doing this, location. And so you could use an RFP process to solicit consultants to do that. We've used one group. It's called the Marijuana Policy Group out of Denver. They were the first ones to really engage and set up functioning enterprises in Colorado. Something that we've always kind of looked at in these RFP processes, how is this consulting group going to be working with the tribe, and what's something that they can be giving back to the tribe as they're doing their project. So are they training tribal members in the new farming methods? Are there certain staff in the lands department that are getting training on environmental compliance? So the second approach, which I touched on earlier, was the operator approach, which establishes all the facilities for cultivation, production, extraction, retail, all would be occurring on tribal land, a vertically integrated project. And you're doing that to demonstrate to a court that the value is generated on the reservation. In this case, the tribe could be creating a regulatory authority, and then that authority would then issue a license to a wholly owned tribal enterprise like a Section 17 corporation or LLC. So under the CFR, can this work for allotments? And for hemp, certainly, I think it does. For cannabis, marijuana, at this point, I don't think it will. Leases approved on allotments, they're subject to federal laws. Again, any federal law is applicable to allotments. So if marijuana is a Schedule I substance, there couldn't be really a tribal enterprise on an allotment that's violating federal law. However, under the hemp market, you could look at what they have as owner-managed interests. And so if an allotment had all of the owners with fractionated interests agree to an agricultural lease, then this is passed under the Indian Land Consolidation Act. They would apply to the secretary to have an application approved that would allow them to enter into agricultural leases for 10 years, and they would be exempt from secretarial approval. And with the case of hemp, you're not violating federal law anymore, so then that would be something would be completely legal, I think. But when you're in this owner-managed interest status, those agricultural leases, they're exempt. So that means all the revenues that are generated from that hemp production, they're all going directly to the landowners. They're not being submitted to trust accounts or anything like that. The BIA doesn't have any review or approval of any of those leases as long as they're for 10 years or less. But all those leases are going to be subject to tribal law. So again, it's important to have tribal laws in place that review these. This is becoming more of a concern amongst some of the clients. Is the tribe is in a state that's legalized recreational use or medical marijuana, and the tribe has strict drug workplace policies. And a person who is a medical marijuana patient is working for the tribe. The tribe is not obligated to accommodate that person's medical marijuana disability. And in addition, the tribe, even though the state has legalized recreational use or medical marijuana use, the tribe does not have to abide by any of those or accommodate any of those laws. So they would still have pre-employment drug screening, ongoing drug workplace policies, so that you're not operating under the influence at work. What happened though is in one scenario was there was the pre-employment drug screening, and there was a job that was open, and they could not fill the job because everyone was screening out for THC. So there was it's just a practical outcome of this is like you need to hire somebody, and there's a pool of applicants, and you're automatically screening out a large chunk of them because they were testing positive because of that workplace policy. So it might be something to consider amending something like that, where you don't have pre-employment drug screening, but you still have in place your workplace drug laws. That would mean then certain managers are going to have to be trained in detection of somebody who shows up to work high or is operating under the influence. And we sat through a lecture with a tribal police officer who was trained in how to recognize those kinds of conditions, and then what would be the practical implication of someone who was determined to be high at work. There is a blood test that you can do. You can take a blood test, send it to a facility. have it tested for whether or not the THC content in that blood sample is active THC or if it's just dormant. So if it, in the case somebody had dormant, THC, they might have been smoking last night or something like that, and it's been over 3 to 4 hours, so the active psychoactive component is no longer there, but that THC is still in your blood system. So even though you tested positive for THC, that didn't mean you were actually high. So that's something to consider. But I mean, it's a difficult thing because what we learned was that when you're under the influence, it's about like a 3-hour process from when that THC goes from psychoactive to just being dormant. The time that it would take for a manager to look at somebody, make the decision that they needed to do some sort of evaluation, call whoever is the trained officer to take a blood sample, come over, take the blood sample, send the blood sample to the testing facility, have the testing facility run their analysis, come up with a result. Maybe 3 hours is gone. So there's just some practical implications for that, but most of the time the decision was we may change the pre-employment drug screening, but we're not going to change anything else. And that's just what we're going to deal with. And if we think someone's high, we're going to go and do our own existing internal procedures. But it's something to look at amending. These are some other concerns: impaired driving. This is why they talk about operating under the influence. You're still subject to all those laws. Just because it's legal, it doesn't mean you can do it wherever you want to. In most of the state laws that we've reviewed, if you're operating under the influence while driving, it's the same thing as like a DUI or DWI. It's a lot of people. There was a lot of when they passed this in Maine, a lot of people just, oh, it's legal now, and so someone actually set up like a lemonade stand on the side of the road and started selling. And we were just like, no, it doesn't work like that. So it's a new market, and it's something that we had to begin to understand and really test and see what the practical implications are. In Maine, there is a gas station where you can go get your gas. You can go into the store, and they have all of like that display that you saw, all of the marijuana products there available, and they're selling only to medical marijuana patients. So they have to have a card and show them that. But Maine did pass recreational marijuana, so that's going to change. And so sooner or later, you'll just go to the gas station and pick up your cannabis. I mean, it will become more normalized, I think, in that sense. So under tribal control, I think there's really 4 important points that we should come away with. Compacting, I think, is probably the safest way. I don't necessarily, that's not my initial position. Everything is, inherently on tribal lands. It's inherently sovereign authority. So if a tribe chooses to engage in something, it really shouldn't be subject to state approval in that sense. So, but if you're all of the, as I mentioned, all of the laws that have been proposed, all of the policies that have been proposed for tribes is that they either meet or exceed state laws. So if in a compact, if you're able to show that the state law allows like smoking clubs in certain areas, tribes could either just say, we're not going to have smoke rooms or smoke clubs. We're just going to meet everything else that the state has, but that one, we're not going to be allowing that. So in that way, you'd be showing that you're exceeding state law standards. Vertical integration, again, demonstrating that you're creating value on the reservation. If you're going to go in that approach, the scales weigh in your favor for a preemption of state law. And then the tribal laws that are passed, I think it's really important that they consider these marijuana and hemp products agricultural products. If the tribal law says that these are ag products, then there's a lot more room under federal law to engage in these markets. As I mentioned, in that like the owner managed interest status. If you're operating in accordance with tribal law and you're creating something that the tribal law says is an agricultural product, then you're good to go. But I think those are 4 key points that tribes should be considering when they decide to engage in this. But that's really, that's my presentation, and I'm happy to answer any questions or any discussions.
Under the regulations that are for cannabis, it always states that it's cannabis sativa. Does that same regulation transfer over to cannabis indica?
So cannabis indica,
Yeah.
it would be like a different strain that you're producing. It's the same.
Okay, I was just wondering, because
Yeah.
all the wording always words out to sativa. Mm-hmm. It never includes the indica strain in it, so is that?
It's the cannabis indica, it's the same.
Okay.
It's going to be covered by federal law, and cannabis indica is going to be on the regulated substances list.
Okay.
The name, it's not so much, but it's just the THC content, 0.3%. Anything below is hemp, anything above, that's a Schedule 1 substance.
Okay.
Anyone else? Yes.
You mentioned the 2018 Farm Bill for tribes that want to produce hemp. And you indicated they had to submit a plan for approval to USDA. How does the Farm Bill apply to individuals? Because you also mentioned individuals and could possibly do an owner-managed lease. So how does the Farm Bill apply to individuals?
Right. So to do hemp, a state or a tribe has to submit a plan. Individual tribal members who want to engage in hemp production, the tribe would need to have that plan in place first before that individual engaged in hemp production, so that that individual is operating in accordance with tribal law and the tribal plan. If the tribe doesn't want to submit a plan, that individual can then go directly to USDA and get an individual license. But so far, what I know is that Kentucky, Navajo, and some other states have already submitted plans, but they're not going to be reviewed or approved until the USDA has finished their rulemaking period. So, anyone else? Yes.
So in California, especially Northern California, the industry is widespread. So I'm working with a commercial broker to potentially lease a 65,000 square foot warehouse facility. and it's on fee land that the tribe owns. So
Mm-hmm.
what about the implications for the tribe, like leasing fee property to an LLC or some type of group that's engaged with these activities? What are the implications and
so-
requirements?
In Oklahoma, that's the same situation. Oklahoma state law for medical marijuana, they specifically called out that this will not apply to individual allotments or tribal lands. So the response to by tribes has been, okay, well, we'll just, we have some fee lands that we own, or there's a tribal member that owns fee lands, and we'll just create a joint venture agreement or a joint venture partnership with that individual, and then just get a state license and operate under state law. The tribe can certainly do that. They can have an LLC that they've created, and they can put up an operation on fee land that's operating under a state license.
So what if the tribe isn't involved in the activity, but is just receiving rents from it?
Yeah, I think there's absolutely, as long as that person is operating in compliance with state law, that the operation is legal itself. But I don't see there's anything wrong with a tribe, tribal LLC being a landlord and having a lease agreement with someone that's operating a cannabis facility in accordance with state law. My hope, or my initial response to all of this is that, this should be, something that tribes can be doing on their own, just under their inherent sovereign authority. The tribe wants to engage in this, they pass a tribal law, and, they, like I mentioned, they could be the market participant, or they're just issuing licenses to tribal members, similar to a smoke shop system. But the reality is, there's been, if you saw, was it Yankton or Santee that tried to do a marijuana resort in South Dakota, and they ended up getting in a whole bunch of trouble. I know in Northern California there was a Pinolville Pomo band. They ended up getting raided because they were exceeding state law requirements that made them comply with county regulations. So while that's my initial reaction to this, but I also would not encourage a tribe or a tribal member to engage in an activity that the risk is very high and that they could get really in a lot of trouble. So everything that we've advised on is just to have a really measured approach, and your best bet is to either, like I said, meet or exceed state standards, and that's really pretty easy to do. Some of the tribal laws that I've written, I just took what the state had come up with and what the state regulations were, and just pretty much mirrored that into the tribal law. But there are certain things that the tribe, we know that they don't want to do. So, like, there's certain things like meeting state building standards. Well, the tribe might have its own code enforcement officer and its own tribal building code, so there's nothing wrong with having the tribe administer its own building codes and mirror what's in state law. But I think ultimately, as the market continues to grow and then legalization efforts begin to move, you're just going to see more and more of the opportunity there. Under the compacting, there's been certain provisions that the tribe would tax at the same rate as the state, and then the tribe keeps that tax. Right there, I think is where you're going to have that investment opportunity and that higher return. So, anyone else? I know. I'm sorry, I didn't bring samples. I thought I got asked that so many times since I've been here, but you come out to Maine or wherever you are in California. But
Hi, you briefly touched on that 25 USCA owner managed interest. Can you talk a little more about that?
sure. So it was a provision that was put in the Indian Land Consolidation Act. If you get 100% of the owners with fractionated interest to agree to apply for a owner managed interest status, that means that you would. What I did is for our allotment is I just got it from Creek Nation. The realty department has a form, and you would just have, it's just basically my mother and her sister, and so they would just have this application, send it back to Creek Nation. I think Creek Nation would take it to the secretary either in DC, or they would just send it to the one in Muskogee. Secretary signs off, says owner managed interest, interest status would then be designated to our allotment. And that would allow us to engage in agriculture leases for 10 years or less without having to go through secretarial approval. That I think frees up a lot of opportunity to create maybe a hemp production facility under an owner's managed interest status. But what would help even more is that there was a tribal law that talked about hemp production, and so that you would be able to demonstrate you're acting in compliance with tribal law. So, but as I mentioned, though, when you're exempt during that 10-year period, all the revenues are going back to you or to whoever you and the joint venture party that you've entered into with, and so it's not going to any trust accounting facility or requirements or anything like that.
Go? Yeah. Okay. Hi, I'm the realty director for the Yankton Sioux Tribe, and South Dakota, we don't have hemp or marijuana legalized. We're one of the few states that will probably be the last. I do have, now we don't have any type of tribal ordinance or code for hemp itself. I know it's been talked about, and I think that our lawyers are going to draft something just because it's a move with the future. As a realty director, I don't know too much about hemp or marijuana or anything, but I know we have a big push for that back home on starting this. Let's get this started. But being that, and I, again, don't know and I'm not familiar with this, so being that it's not approved on the state federally, we have federal lands with trust lands, but what I'm gathering is that we're going to have to wait until the state passes it. Is that correct? Until?
No. So for hemp, it's you can go and start. You can get a plan in. Your tribe can submit a plan and have its own tribal codes, and then it can enable either the tribe or individual tribal members to engage in hemp production. That can happen. That's going to happen, by the end of the year.
Okay.
You just have to have your plan that's in compliance with USDA regulations.
And that has to be submitted and go according to the farm bill. I think it's like 40 acres
Yep.
or something.
Yep.
Okay.
But for marijuana, which is that
Right.
higher THC concentrate, that won't in South Dakota.
Yep.
Unless South Dakota decides to engage in medical marijuana or some form of legalization. Decriminalization, I think it's a gray area. I'm not really comfortable in saying that because the states decriminalized marijuana, that means the tribe can start putting up enterprises. But if it's that those different scenarios that I went through earlier, where
Right.
The state has no enabling legislation for anything, and the tribe maybe wants to do it. I think the tribe is very limited in engaging in that, because the risk is I think it's much more intense when the tribe is trying to do this without any sort of compliance with state law.
Okay. Thank
Even
you.
though I think that that's what we should be doing, we don't have to go, we don't have to be waiting on states to pass their laws, but I just, because it's still illegal under federal law. Now, if the federal law changed and said everything, the THC content, everything above 0.3% is now legal and marijuana is taken off the Schedule I Substance Act, then it doesn't matter what South Dakota says. The tribe can do it all on its own because they'd be operating in compliance with federal law.
Right.
That's why that's what's really kind of holding this is that there's no federal approval, and the only indication that anybody got from the feds was you need to be in compliance with state law. So that's the cautious approach right now.
Okay, thank you.
Okay.
Is there any tribe that has a compact with the state?
Yeah, there's a few in Washington that have gone into compacts for the states.
Washington?
And they've, I mean, I don't know the details of every single one, but I know in the one that we worked on, that in that provision of the compact, the tribe was going to tax all their retail sales at the same rate as the state, but the tribe was going to keep that tax revenue, and they weren't going to have to remit some percentage back to the states. The tribe was keeping it all. And what was explained to me from someone who worked on that on the state side was that the state wasn't really concerned about the loss of revenue. They just wanted to make sure that there was the tracking system in place for tribes, that they were tracking, they call it seed to sale. And so you need to show from where that final product that's being sold to a consumer, where it came from all the way back to what plant it grew on. And so states have put in place these tracking systems. And for one of the clients we worked with, the tribe wants to have its own tracking system. Other tribes were okay with kind of creating integrating all their software and everything into the state system so that the state would know where all the seed to sale transactions are occurring. So in that case, the state was just really more concerned about security and monitoring and compliance on the tracking.
Okay, thank you.
Yeah. Great. Well, thank you for your time today. I mean, we talked about the naked gun. I mean, we covered. I know we covered a lot here, but I'm available, and I have some material as well if you're interested that I can give you too. So, thank you again.